in the Brandy Levy case, it was all on her, basically talking to her followers on,
That's right.
on Snapchat, and then the school stepped in. And this has been a problem for quite some time, where schools have incrementally said, we are more in charge of your kids, regardless of the time of day, regardless of the location, to the point where lots of us parents, and I get to be a parent all over again, they almost seem like it's our children are their children instead, and that we are just getting in the way.
That's right.
And in this case, is this one of those?
Absolutely. I think this case is an illustration of the fact that increasingly schools see themselves not only as institutions that are there to inculcate the appropriate ideological beliefs in students, but they also now think they're there to enforce the appropriate ideological beliefs. Now, you're right, Skip, that the window has been closing insofar as schools are getting more and more restrictive in what speech they regulate. That's what they're attempting to do. But I think our US Supreme Court has done a pretty good job of holding the line and protecting students' free speech rights. And in New Hampshire, as I mentioned, this is the live free or die state. Our Constitution is actually much more emphatic in its rights than the federal Constitution is in articulating its rights. And so our Supreme Court tends to be even more protective of rights like this one than the federal Supreme Court. So it's important to remind schools of that and remind them that they have zero constitutional authority to regulate the content of student speech.
As far as the administration is concerned, was this brought to a teacher, a department head, an assistant principal, the principal, or even the school board by whatever means that they have in SAU 16? I, as a parent, would immediately be going to my elected representatives, the school board. But how did SAU 16 handle this?
I assume you're asking about how the complaint against my client was brought to the school. So what occurred is he had this initial discussion with a student who disagreed with him on the school bus. That student then initiated a conversation with our client via text message. The student then screenshotted those text messages apparently and turned them over to the school. We don't know that for sure, but what we do know is that the morning after these text messages were exchanged, the vice principal and the football coach pulled our client out of his early morning science class, and they then confronted him with printed copies of these text messages.
Who was the assistant principal that was involved?
Marcy Dovhaluk is my understanding of how to pronounce her name. I'm sure I'll learn the correct pronunciation in court, but that is my understanding.
And what about the football coach?
The football coach is William Ball, who is not a defendant in this case. This is a suit against SAU 16, the school district, and against the vice principal who's been sued officially and in her individual capacity.
Okay. Did this get to the principal, or did it stop with the assistant principal?
The principal did learn of it because the mother of our client, after she learned about what had happened, contacted the principal, the vice principal, and Coach Ball.
Did the principal then go to the superintendent? And I'm just climbing up the chain here.
Well, we don't know what the superintendent knew. I expect we'll find that out in court. Certainly the media has been talking to the superintendent, and he hasn't made any very specific statement about the case. What we do know is that the principal did not step in and rescind the athletic penalty that had been imposed on the student.
And this is Superintendent David Ryan, correct?
David Ryan is the superintendent of SAU 16. That's right. So at some point, a decision was made by someone to modify the 1-week suspension to turn it into a 1-day suspension. But as I pointed out earlier, that actually makes no real legal difference here. The government is not allowed to violate your constitutional rights and censor you as long as they do it just a little bit.
Okay. Most people call them school board members. I'm trying to make sure that people understand they are your elected representatives and they are accountable to you as voters. Have they made any press release, any utterance, any other kind of communication to the family and to the SAU district parents at all?
To the best of my knowledge, every time a media outlet has contacted the school district or anyone at the school board, the most that they've heard is that they're still assessing the merits of the case.
Okay. So where does the case stand? I take it has been filed, because for full disclosure, we did take the Cornerstone action press release. I posted it personally on Granite Grok, because it is very similar, again, to mine in SAU 73, except I added one other clause, which was in part of the privacy, the lying by omission or commission of staff to parents, where they would never tell the parents that their child has gone transgender in the school, which I think is absolutely horrible. Again, adding to they think that our kids are their kids. But you're not touching that at all.
That's a different legal issue. We're only addressing here the First Amendment standard under Tinker, which is specific to students. So we're also not getting into the extent to which school districts are trying to regulate the speech of teachers. That's a different standard. There's a student-specific standard, and under that standard, you cannot prohibit the expression of a particular opinion unless it has this substantial disruption of school discipline that's required to warrant that prohibition. And that's just not there in this case. It wasn't there in Mahanoy, where multiple cheerleaders were upset. So it certainly can't be here in this case, where only one student that we know of was upset.
Do you know at this point if there are any other incidents of similar behavior by the school staff and administration towards others, or is this the only one that has come to light to your knowledge?
Because I believe there may be other attorneys working on those kinds of matters, I'm going to err on the side of not commenting on any other attorneys' cases and just commenting only on my own case.
Oh, okay. Then I won't ask that question in any other form at all.
All right.
I've got other things I'd say, but I won't either.
Okay.
You know who I am, Ian. I can't hold myself because I just can't help myself at times.
That's all right. Doesn't hurt to ask.
Yes.
Croc TV.